rise. The Court of Appeals Division 1 is now in session.
Please be seated. Morning, counsel. Let me call the case. This is case CV140656, in re the matter of Scott Brittenham and Betsy Brittenham. This is the time set for oral argument. Counsel, as you are aware, these proceedings are being recorded. You may not be aware they're being audio recorded and video recorded, and at the end of these arguments, they'll be uploaded to the internet. So I want you to be aware of that before you make your arguments. Please identify yourself and your client when you come up to the podium, just so we can make sure we have the right parties and attorneys. You both have 20 minutes. Counsel for appellant, you can reserve some time for your rebuttal. Just let us know, and we'll try to make sure that you have that time. We've read the briefs. We've discussed the case. We're very familiar with the issues. So keep that in mind, and you can keep track of the time on the clock on the podium. And is it Mr. Maltz?
Yes, Your Honor.
You may proceed.
Please, the court, I'm Gerald Maltz, and I represent Scott Brittenham, who's present in court. As the court has seen from the briefs, the principal issue is the scope and application of the law of restitution to the facts in this case. The judge below found that Mr. Brittenham, without any obligation, paid all the debt on Betsy's policy. She also found that as a result of his payments, it created cash value in the policy. The numbers that are not in dispute are that when he began making the payments, erroneously believing it was his policy, the cash value was $5,800. At the end of the day, it grew to $354,000. The court below awarded restitution in the amount of $158,000.
Mr. Maltz, let me back you up for a minute, because I want to see what your vehicle is that you took this, or your client took this in before the family law judge, so we can focus on what the family law court did and then what we have here really in front of us on appeal. You are basing the claim and what you believe to be error on the court erroneously ruling on the unjust enrichment claim by your client?
Yes, not awarding the full measure of restitution. Yes, Your Honor.
All right. Now, we know that the marital settlement agreement was merged into the decree, so there's no independent contract right. So we have the decree. You would agree that the court could only enforce the decree at the point when your client came in and wanted reimbursement for these payments, right?
Yes.
All right. So tell me how the unjust enrichment claim is woven into enforcing the decree.
It's not. Because we elected the remedy of unjust of restitution not to amend the decree. And when we made that election of remedies, the restitution remedy was not dependent upon enforcing the decree or amending the decree, because the facts that give rise to the remedy, Mr. Brittenham's payment of the debt and creating cash value in the policy, was not an obligation under the decree. It was independent of that.
Okay, so you're claiming that that your client had a right independent of the decree to obtain restitution for the value of the policy?
The value of the unjust enrichment, yes, Your Honor, which is the cash value of the policy. That ending cash value of $354,000 enables Betsy not only to withdraw it, but to borrow against it. And she never did anything to create that value.
So the essence of your argument is you're trying to reopen the decree, aren't you?
No. No.
Explain that to me. How are you not trying to reopen the decree when you are saying that wife obtained a value of a marital asset that really your client increased the value of that asset and should get the benefit of that asset? I mean, it's a marital asset that we're dealing with. The policy was part of the marital community, right?
It was a marital asset that was awarded in the decree to Betsy. We are not seeking, by electing restitution, we're not seeking to change the marital settlement agreement. We are not seeking to amend or change anything in the marital settlement agreement. We're not seeking to reopen the marital settlement agreement. Our argument, Your Honor, is that independent of the marital settlement agreement, which did not provide any obligation for Mr. Brittingham to pay anything on her policy, independent of that, he erroneously, after the fact, made payments on what turned out to be her policy.
So you could have brought this in Superior Court without reference to family court.
I think so, yes.
You're not. If I'm hearing you correctly, see, I thought you might have answered Judge Gould's questions by saying it's the family court enforcing and putting into action that which should have been done in 2000. Ownership of the policy is transferred, and a restitutionary payment is made because Scott made a payment that Betsy should have made, or that's the argument. But instead, you're telling us that it's totally severed from?
Yes, because I don't have firsthand knowledge of why my predecessor, who handled the matter in family court, went to family court. I believe I know why, because the options.
Well, I know why. He filed a petition regarding the decree, a petition to appear. He didn't file a separate action. That's
Correct.
why it's in family court.
Correct. But I think that was a procedural choice where the option was to file an independent civil case for restitution
No, but I'm almost, counsel,
in the
I'm almost-
Superior Court.
I'm almost flabbergasted when I hear you tell me that you're trying to enforce a cause of action that is independent of the decree when we're here on appeal on a petition that was filed to enforce the decree, and you're saying it has nothing to do with the decree. I mean, I'm wondering why you're even here.
Well,
I mean, I'm not trying to be sarcastic. I mean, I'm having a hard time understanding what you're basing the unjust enrichment claim on when it's all the litigation has been in the context of your client's petition to enforce or modify the decree, however you characterize it. I wasn't trying to be insulting there. I really am wondering.
well, the option, when it was discovered that he had been paying money and enriching Betsy by paying on her policy, was either A, to go to civil court and file a new action for restitution, or to get immediate relief by filing this petition to appear, and happened actually in a matter of a couple of weeks since the notice. Now, the petition to appear at that time talked about amending the decree, or alternatively, if not amending the decree, awarding Scott restitution. That was followed by the election during the course of the arguments, and started as a motion, wound up as a trial. At the trial, and after the trial, Scott's counsel elected the remedy of restitution and did not seek to amend or change the decree or the ownership of the policy.
Was there a specific discussion of this election?
I don't know. But that's what happened based on my reading of the record.
Okay.
But to have a remedy, you have to base it on a cause of action. What's the cause of action that the remedy's based on?
Unjust enrichment.
Okay. Well, look, when I read the decree, I have some questions for you. It seems to me that what Judge Maxwell did in her order was enforce the debt obligation that was assigned to wife. What do you say about that? I'm looking at the decree, and first of all, I'm not even sure the court granted the unjust enrichment claim. I don't see where the court makes that statement anywhere in here. It kind of picks up that claim and looks at it, and indeed, a lot of the findings really don't seem to support that, but then the court gets into the debt, and it certainly, it is therefore ordered on the last page of the order, the respondent shall pay to petitioner the amount of $158,000 as and for the debt owed by her on the Northwestern Mutual Insurance policy. That sounds like the court's enforcing the debt obligation of wife.
No, it's granting restitution, and we concede that the conclusions of law are convoluted and don't necessarily follow the findings of fact, and that's one of the premises for the appeal. But I think if you look at her conclusions of law, she does conclude that Betsy was enriched to the extent of $158,000, which was the debt at the time Scott started paying. But she also made findings of fact that as a result of his payments, she made a specific findings of fact, it created cash value. And we know what that cash value is because it's math.
In those findings, does the judge ever phrase that impoverishment or enrichment in any terms apart from the amount of the debt?
No. She says that the enrichment was only the debt at the time. This is her conclusion. And that the impoverishment was only paying that debt. But that doesn't follow her findings and the undisputed evidence that in addition to paying off the debt, created cash value 60 times what it was before Scott started paying. And in order to correctly apply the law of restitution, you don't need a corresponding loss to a benefit. We've cited the cases. You grant entire restitution. The analogy we would make is that if this were a bank account and Scott made a deposit of, let's say, $100 erroneously, and because of interest and dividends and so forth and so on, it increased to $500 at the time it was discovered, and Betsy says, that's my bank account, turn it over to me. Is restitution the $100 or the $500? Certainly $500.
I understand the argument, but in reading Judge Maxwell's order, I don't see her treating this claim in that fashion. I see her repeatedly looking at there was a $158,000 loan that existed at the time Ms. Brittenham was assigned this asset, and your client paid for it, and she's now to reimburse your client for paying her debt. I don't see her talking about this $158,000 in terms of the value or any increased value.
Well, no, she doesn't, and that's the problem, because she did not award full restitution.
But having availed your client, having availed himself of family court, and having placed the matter in the context of family court, is it not within the discretion of the family court, particularly if we view it as an action related to carrying out the terms of the decree, and maybe with a little equity poured in there, was it not within the discretion of the family court to say, I'm going to award the 158 or 159 to Scott, and I'll use first names because it's easier, I mean no disrespect, but there are some offsetting things in my mind about benefits and detriments to Scott and Betsy, and so I'm going to stop there. Why isn't that just within the court's overall discretion at that point?
As a general proposition, I would agree certainly that the family court has equitable discretion to split the baby. However, that's not what was at issue when the case was submitted to her. What was at issue was the application of the law of restitution. In fact, in her conclusion, she talks about the law of restitution, and she attempted to apply the law of restitution, and she does it in kind of a schizophrenic way, because on the one hand, she uses the language of restitution, talking about unjustly enriched and impoverishment. That's restitution. On the other hand, she seems to indicate that restitution should not apply because there is a contract between the parties. And we've distinguished that argument in our brief.
Yeah, on that score, is it your position that there's no contract because it was merged into the decree?
There is no contract that affects the operative facts of the restitution claim, because
This was beyond the contract.
It was beyond the contract.
Separate from.
Yeah. The case was closed. It was her policy, and he erroneously paid on it for a number of years. And now, when, at the end of the day, when she gets it, she gets something that is worth 60 times what it was worth at the time of the decree. In fact, this policy was a liability rather than an asset at the time of the decree because it had a substantial loan balance. And we know that in 3 years' time it was going to be lapsed with a $100,000 tax liability from Betsy. He actually rescued it, took the ugly duckling and turned it into this beautiful swan on the misunderstanding that he was paying on a policy that would eventually inure to the benefit of his children. She takes the swan and she doesn't have to reimburse him for the full value. It's just unjust. So even if we were dealing with the family court as a court of equity, putting aside the fact that she erroneously applied the law of restitution, how do you justify that on an equitable basis? It's at least a $150,000 windfall to Betsy. And the whole purpose of unjust enrichment and the law of restitution is to prevent exactly what they're claiming they're entitled to, a $354,000 windfall. So with that, Your Honor, I say I have 4 minutes. Unless there's questions, I would reserve my time for rebuttal.
No, thank you, counsel.
Thank you.
All right. I misplaced my paper. Counsel, Ms.
Ms. Stanton.
No.
Good morning, Your Honors. Sarah Stanton, representing appellee cross-appellant Betsy Brittenham. Mick Rusing is also with me today. I'd like to reserve 3 minutes of my time for surreply, if I may.
You know, I'm not sure that we do that. We'll see where we are at 3 minutes, okay? I'm going to deny that request right now.
Okay,
but,
thank you, Your Honor.
So use your 20 minutes, but we'll see, okay?
Okay, thank you, Your Honor. I'd like to touch on some of the things that Mr. Maltz said and some of the questions that this court has posed. This case really comes down to one thing, and that is, what is the theory of liability that supports an award of damages to Scott Brittenham, whether it be $158,000 or any number? And the answer is that there is none. Now, I believe Mr. Maltz just said when he was up at the podium that the theory of liability that they have proposed is unjust enrichment, and that's supported by the briefs. That's the only theory of liability that Scott Brittenham has presented in his briefs and that we've been arguing about.
It's the correct theory, isn't it?
I'm sorry?
It's the correct theory. When somebody makes a payment that somebody else should have made, they have an opportunity to see if they qualify for reimbursement.
I'm sorry, just a minute. I apologize. You had a cross appeal, so you can reserve 3 minutes. My fault.
Thank you, Your Honor. Appreciate it. Yes, Your Honor. That would be one of the avenues that somebody would try to pursue in that type of situation. In our particular situation, the trial court correctly found that unjust enrichment did not apply. And it's because of the Ashton rule that it says that when there's a contract between the parties on the same subject matter of the unjust enrichment action, that cause of action is simply unavailable. And the trial court did find...
Read, I think it was on page 5, and apparently I walked out without my copy of her ruling this morning, but I believe it's in the middle of page 5 where it seems like she's about to say it doesn't apply. And my friends have handed me a copy. Let's see if that's where it is. Yeah, it's about in the middle there.
Yes, Your Honor.
I object to the use of the word friend.
Well, actually, I withdraw it. But she does go on to say there, the respondent was enriched to the extent that her debt was paid by petitioner. The petitioner has not demonstrated how he was impoverished, etc., except that he paid a debt assigned to respondent in the marital settlement agreement, which certainly strikes me as an impoverishment because he's paid something he didn't have to pay. And so I'm not so sure that she rejected unjust enrichment.
Well, Your Honor, as you were saying, you said it kind of sounded like the court was going that direction, and I thought so too, frankly. I was reading the ruling and I thought, okay, the Loisel case doesn't apply because there's no fraud or, anything misconduct on Betsy's part. Okay, Ashton rule applies. There's a contract between the parties. Oh, wait, there's an award of $158,000 to Scott. What could that be based on? Because the Ashton rule either applies or it doesn't. I mean, it's our position that it clearly applies because the MSA explicitly lays out what is to happen to that life insurance policy following the dissolution of the parties' marriage.
But the MSA as a contract for enforcement purposes is gone, because it's merged into the decree. So now we have a decree, not a contract anymore, if I understand the doctrine of merger correctly. Which has always baffled me. I'm not sure I would write it that way if I was king and starting over, but that doesn't matter.
That's correct, Your Honor. The dissolution decree is a final judgment, and there are very specific circumstances in which a final judgment can be reopened. And I'll get to that in just 1 second. I just want to make one other point about the MSA. It is a contract between the parties on that same subject matter. And it also does not make that $158,000 Betsy's debt. Scott has continuously argued that he has paid Betsy's debt. That
was her choice whether to pay it off or not. Is that your point?
Yes, Your Honor. She could have let the policy lapse.
Sure.
She could have paid off that existing loan the day after the dissolution decree was finalized and she received the policy. She could have done any number of things with that policy. She was not required to ever pay that $158,000.
Well, to the extent it was a debt owed by somebody, though, it was her and not Scott.
Well, the asset that she received, which was the policy, was subject to that loan. So that's correct, Your Honor. Scott wouldn't have been obligated to pay it either.
Right. Well, between her and Northwestern Mutual, there was some obligation, but if you don't pay it, the policy lapses and you probably have a taxable event.
Right. And that would have been her choice to make. And, she was deprived of making any choices about the policy for those 13 years that Scott controlled it. And the trial court properly found that he did so knowingly. He knew that the policy had been awarded to Betsy.
Well, as I recall, and again, I don't have it in front of me now, but I think the court said it is likely that he was not unaware or something like that. And I tried to take all the negatives out of there and just figure out what was left, and I concluded I didn't know what she meant.
I understand, Your Honor, because we had some confusion over that as well. And it's paragraph 7.1 in the trial court ruling. It's at appendix page 4. And it says, it is unlikely that the petitioner was unaware that the respondent and not he was the owner of the policy. And it discusses the fact that Scott Brittenham had testified that he had 33 years of investment bank background.
It sounds like she was coming close but not quite saying that she thought he was aware. But she said it was unlikely he was unaware. I'm not sure what that means.
To me, Your Honor, it reads that she was kind of taking the testimony of the parties, looking at what each party had said about their actions, and was making a determination based on Scott Brittenham's credibility, in her view. I want to touch on another point that Your Honor brought up, which is the final judgment issue. So the
merger issue?
I'm sorry?
Merger issue?
Yes.
Okay.
So the MSA was merged into the dissolution decree, which became a final judgment. And the trial court also erred by allowing Scott to reopen that final judgment without following the necessary procedures that are pretty clearly laid out under Arizona law. ARS 25327 says that the provisions of a dissolution decree dealing with property disposition may not be revoked or modified unless the court finds the existence of conditions that justify reopening a judgment under Arizona law. And then the relevant rules that kind of lay out when it's justified to reopen a judgment are Family Law 85.
Counsel,
and
I don't think the court reopened the judgment. I mean, the Schrock case it seems like it's pretty much on all fours with this. I know that your position is that $158,000 wasn't a debt, owed by wife, then why would the court in the decree or the property settlement decree even mention it? Why would it say that that loan is wife's responsibility under this decree? If that isn't a debt, I don't know what is. And if the court can't reimburse vis-a-vis between two spouses, one spouse who pays a debt that's assigned to another in a decree, that's not reopening the decree. That's just the court saying, we identified this loan on this community asset that you're getting as your responsibility. It's your obligation. It's not husband's. Now, you can't make third parties. You can't make creditors. You can't enforce it in that fashion. But between these two parties, you can say, you're going to pay this loan. Husband doesn't. You get the policy. He doesn't. And at this point, the court cuts through a lot of what the filings are and says, at the bottom of this case at its core is, wife was supposed to pay the $158,000. We couldn't make her pay it, but when husband pays it and it's not assigned to him, we can make wife reimburse husband for that money. Isn't that what the court ordered? And surely the court can do that under the Schrock case.
I don't believe that the court can, Your Honor. And I think the difference is that assigning a debt to one spouse is different than assigning an asset to a spouse that does have debt on it, but doesn't ever have to be paid. I mean, Betsy could have never paid that $158,000 if she hadn't wanted to. That was within her discretion to do so because that was the asset that had been awarded to her.
And because of that, your argument is that in slightly different words, Scott's just a volunteer.
Exactly, Your Honor. Scott voluntarily made those loan payments of his own volition and then proceeded to, of course, use the policy for his own purposes, borrowing over $450,000 from the policy over a period of 8 years.
But isn't the assignment of debts also a balancing of the assignment of assets? In other words, when a court assigns assets to parties, it also looks at the debt that's on that and weighs, is the court's supposed to make a relatively equal assignment of the community assets. And so when a court assigns an asset that's worth X amount of dollars, it's certainly going to consider the debt on that. And so in that sense, when a party comes back and the other party that lost that asset pays the debt, it's not the value that the court had assigned. And so debts are important to enforce between parties in that sense because it's built in the division of community assets, isn't it?
I understand the point, Your Honor, and overall I would agree with that. Again, and I hate to keep hammering this point, but I would argue that it's a little bit different because this wasn't a debt that actually had to ever be paid. She could have let the policy lapse and not paid the debt if she had so chosen.
Well, that would apply to any debt. I mean, you know, both parties are on a credit card. Courts go through, and I did this many times. You assign the obligation for paying the debt on the Visa credit card. Now, a party could say, well, I don't ever have to pay that. Right. So what's the meaning of assigning a debt to a party? Right. Because the other party's name is on it, and so they're stuck with that liability. That would apply to houses, cars, sure, credit cards, anything where there was a loan on it. So to say that you're not assigned that because you don't have to pay it, I'm not sure what that means, counsel.
Well, Betsy that was an asset that was assigned to her, and it's not disputed that loan did exist on the policy at that time. So that is true. Now, the way, and I don't want to get in, because I think it's easy to get into the weeds with some of this stuff, and really I think at the end of the day, this very straightforward answer is that there simply is no theory of liability on which Scott Brittenham wins and gets a damage award at all.
And for your argument, am I correct in surmising that your argument doesn't depend on whether this issue was brought forward in family court or anew in Superior Court?
Well, on that point, Your Honor, the only thing I would like to say is that I think that clearly this should have been brought as a separate claim, that unjust enrichment on Scott's, as far as any unjust enrichment claim that he may have had, should have been brought as a separate claim. And I think the clear answer as to why it was not is that the statute of limitations would have run. His claim would have accrued in 2003 when he made that first $100,000 loan payment, and the statute of limitations on an unjust enrichment claim is 3 years.
Would that be true if he thought the policy was his?
Probably not, but I think it's very clear from the evidence in the record that he did know that the policy was his in 2003 at the latest. I mean, the trial court made a finding that he knew at the time of the divorce that the policy was Betsy's, and Scott Burnham testified that he understood that the life insurance policies had been divided based on whose life was insured under each policy. But even putting that aside, at the very latest, in 2003, he filled out that change of beneficiary form where he actually hand wrote in Betsy Brittenham's name as the insured under the policy, wrote in the policy number, and changed the beneficiary to himself, Scott Brittenham, as ex-husband. And that was something that he needed to do under Arizona law, otherwise...
But those things don't change the owner.
That's correct.
You're saying that should have alerted him that he was not supposed to be the owner of that policy.
Absolutely, Your Honor. I mean, even if Scott Brittenham didn't remember the specific terms of the MSA that the parties had the parties had entered into 3 years prior, he certainly should have found it strange that he still owned a life insurance policy on his ex-wife's life at that time. So I think it's clear that the reason that we're in this today and that this petition was brought in the family court is that there were no other options available to Scott Brittenham because the statute of limitations had run on any claim he may have had.
But was there an objection made by Betsy in family court that, hey, this is the wrong forum?
Yes, Your Honor. And I don't know that I could point you to the specific pleadings at this time, but yes, repeatedly we did make the argument that it should have been, either a breach of contract action under the MSA, which of course then you get into all the merger issues. It should have been a motion to reopen the judgment brought properly under the proper rules and statutes applicable to that, or it should have been a separate action for unjust enrichment in Superior Court. If Your Honors have no further questions, I think I'd like to reserve the remainder of my time for reply.
Yes, counsel, thank you.
Thank you.
By the application of hindsight, it might have been cleaner and easier and avoid the vicissitudes of family law court if this were brought as a separate action. It was not brought as a separate action. And not for the reasons, and I do have secondhand knowledge, not firsthand knowledge, and not for the reasons that counsel mentions. If, first of all, when Scott got notice in February of 2013 that Betsy was claiming ownership of this policy, he went to his family lawyer, which was natural. She had...
I don't want to go outside the record, counsel, for...
Okay.
Is this in the record?
Well, what is in the record?
I can assure you it's not going to be important to us why
Okay.
or why not he chose the form
Okay.
that he did.
Thank you, Ron. That's helpful in terms of me conserving time. At the end of the day, a restitution action was presented ultimately to the court below, whether it's family court or civil court. At the end of the day, the court appeared, I don't know what the correct adjective is, it appeared originally to reject the doctrine of unjust enrichment, but not really. She doesn't really reject the doctrine of unjust enrichment. And then a couple paragraphs later, for the wrong reasons, a couple paragraphs later, she applies in effect the doctrine of unjust enrichment using the terminology of restitution and unjust enrichment. So the remaining issue is, does the doctrine of unjust enrichment apply? Yes, restitution does apply because the Ashton rule does not preclude it. The second issue is, did she apply it correctly? And she did not apply it correctly because under her own findings, she awarded Scott only partial restitution and left Betsy unjustly enriched, at least to the tune of $150,000. Fine. It is her policy. She should keep her policy. She started out with debt. The court found that she knew there was debt against the policy. She had the obligation to pay the debt under the MSA. She had the policy to pay the taxes if she defaulted on that debt, and the policy lapsed. What Scott did is he took this liability and created into a swan and delivered to her a debt-free $354,000 asset, and in the course of it doubled the insurance benefit from about $500,000 to $900,000. And the notion that she can accept this windfall and not account in full for restitution just goes against equity law or just the fundamental morals that the law enforces.
I mean, wouldn't your cause of action then been to reopen the decree and have the court reassess through an equalization payment this increased value that Betsy or wife allegedly received? Isn't that the direction you have to go? It seems to me when you talk about this unjust enrichment and this increased value, at some point you have to get back then into what the court did in the decree and change it.
Not if I were making the decision.
Okay.
If I were making the decision,
I think
would
I got
say,
that point.
yeah.
But, I mean, within the context of at least the dissolution decree, you have to work within that decree. What authority does the court have within the decree when the previous lawyer filed the petition? Now,
Well,
I don't know. I mean,
I can only answer based on what comes out of me at the record, and that was that this was done in a matter of weeks. I mean, there was no statute of limitations. I mean, February 6, 2013, we get notice. February 20, she files a petition. It's 2 weeks. And it was done for the immediate, and they got an immediate hearing in family court. That wouldn't have happened if they filed a new action.
I understand.
And they didn't, she pled alternatively. Either reopen it and assign the policy to Scott since he's done all this, or if not, give him restitution. And at the end of the day, it was a restitution case, and at the end of the day, we submit that the court awarded partial restitution, which is not the law.
Thank you, counsel. Counsel?
Thank you, Your Honors. Mr. Maltz has characterized the life insurance policy at the time of the divorce as a liability and not an asset. And, Your Honor, you asked earlier about how this is different from another debt that might be assigned to a spouse in a dissolution decree. And it is different. It was an asset. It was not a liability, and it is different than a credit card debt. I mean, even if you look in the MSA and resulting decree, the life insurance policy is not listed as a debt, it's listed as an asset. And, with a credit card debt, if somebody doesn't pay that, usually, first of all, they're ordered to pay it in the decree.
What about assignment of the marital residence and responsibility for the mortgage?
Sure, and that still fits in. So usually someone's ordered to pay that, first of all, and second of all, if they don't, something bad happens. I mean, in the context of a credit card debt, the credit card company can sue you. In the context of a marital residence, your home can be foreclosed. You could potentially maybe be sued in certain situations.
In this case, the life insurance company could say, your policy's lapsed, you failed to make the payment.
Exactly, but she wouldn't have any further liability. That would have been her choice to make, that.
What would be the further liability in a foreclosure action, other than losing the house?
Well, typically with a residence, typically the foreclosure would be the only, right.
Or with a car.
Right.
That's it, right?
That's true. I mean, I do think usually, though, debts are ordered to be paid. This wasn't ordered to be paid. This was listed as part of the assets that were awarded.
Why did the court then say, you're responsible you have a $158,000 loan on this policy. Why even bother to do that?
Well, I think the court wanted to make clear that, I mean, I'm guessing now, but, you know, it's from what we have, the court wanted to make clear that whatever loans were on any of these policies were going to be the responsibility of the person receiving that asset and not of the other spouse. And that's true, you know? I mean, the life insurance policies were divided based on whose life was insured. Scott kept a policy that belonged to Betsy. He kept it knowingly, according to the factual findings of the trial court that are correct. He did make a loan payment, and he made that payment of his own volition, and that payment did prevent the policy from lapsing. And then
what is in the record, if anything, to explain why he made the payment if he didn't own it?
Scott Brittingham testified that he made the payment because he received notice that the policy was going to lapse if a loan payment was not made.
Well, I mean, that suggests that he thought he owned it, doesn't it?
The evidence in the record clearly shows that he knew the policy was Betsy's, at least as of 2003. I mean, so he receives the notice from Northwestern Mutual, and we don't have the actual notice in the record, but there is testimony that the notice would have identified the policy by policy number, insured, and beneficiary. Then, shortly after he receives that notice, he fills out that change of beneficiary form that I discussed earlier, where he writes in Betsy Brittingham's name at the very top of that sheet as the insured under the policy and changes the beneficiary to himself as ex-husband. And only after he does that does he start making the loan payments, and almost immediately begins borrowing from the policy after he makes that initial payment, and starting with taking a loan out of over $100,000 in early 2004 after making that first payment in 2003. So, he started using the policy for his own purposes almost immediately after he made that payment, and he enjoyed the benefits of the policy for almost 13 years. Not only did he take over $450,000 in loans from the policy, he also controlled the beneficiaries during that time.
Well, and by the way, when you say he took out $450,000 in loans, he also paid all of that back.
He zeroed out the loans. That's correct. But having that policy as a personal loan source for 13 years is certainly of some benefit.
Could be. Was there anything in the record about whether he could have used some other policy or some other vehicle for his loans if he really needed to?
He testified that he would have had other loan sources. Yes. There's no evidence in the record other than his testimony on that point. Your Honors, I think this case boils down to the fact that Scott Brittingham took something that didn't belong to him, that was indisputably awarded to Betsy Brittingham in the MSA and resulting dissolution decree. He used it for his own purposes for almost 13 years, and now he wants Betsy to pay him over $350,000 just because she got it back. There is simply no legal or equitable basis for such a result, and therefore I would respectfully request that this court reverse the trial court's award of $158,000 to Scott and leave the rest of its ruling intact. Thank you.
Thank you, counsel. We'll issue a written decision in due course. Court's in recess.